users, welcome to this session. In this session, I am going to cover sureties liability. Now, we must have understood that there are special contracts, that is contract of indemnity, contract of guarantee. Under the contract of guarantee, the role of surety is very important and pivotal. So, in order to recall it, surety is a person who is responsible to make the payment on behalf of debtors in case there is a default. So, liability of surety is coextensive with that of principal debtor unless it is otherwise provided by the contract. So, this is clearly mentioned under section 128 of Indian Contract Act 1872. So, when we talk of surety, we must know that these three parties are existing under the contract of guarantee. Let me take one illustration to explain this point. For example, A is guaranteeing to B the payment of bills of exchange by C, that is the acceptor. The bill is dishonored by C, then A is liable not only for the amount of the bill but also for the interest, charges, bouncing charges which may have become due on it. So, surety is not responsible only to the amount. In case bill is dishonored, so noting charges, dishonor charges or the charges of interest nature will be paid by the surety. So, look at this picture whereby I wanted to illustrate principal debtor has an obligation towards the creditor. But in case they default, so surety, that is the guarantor, has an obligation to make the payment to creditor. Eventually, surety will take the payment from the debtor in form of reimbursement. He will take the payment. But if default happens on behalf of debtor, principal debtor, surety has to make that payment to the creditor. So, just understand there are certain rights of surety. One, against principal debtor. Second, against creditor. Third, against co-sureties. I am going to discuss all these rights in detail. In the contract of guarantee, there are three contracts which are present under this. One contract is between principal debtor and creditor. Second contract is between principal debtor and surety. And third contract is between surety and creditor. So, one must know if surety has made the payment to the creditor, what are the different rights of the surety against these three categorically parties. First, I would be discussing right against the principal debtor. See, against principal debtor, he has two rights. One, right of subrogation, that is covered under section 140, where a guaranteed debt has become due and default of principal debtor is there to perform a guaranteed duty has taken place. Then surety, after making the payment or performance of what he is liable for, is invested with all the rights which the creditor had against the principal debtor. So, he will step into the shoes of creditor. This kind of right is known as right of subrogation. It means after making the payment of a guaranteed debt, performance of guaranteed duty, surety steps into the shoes of creditor. So, he will ask for the reimbursement from the debtor like creditor was asking. So, right of subrogation is this right of stepping into the shoes of creditor. Second right is implied promise to indemnify surety. This right is covered under section 145. In every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety to make the payment back after some time. This is known as reimbursement. So, surety is entitled to recover from the principal debtor whatever sum he has rightfully paid under the contract of guarantee. So, he have made the payment of amount, he can claim. He has made the payment of interest, he can claim. He has made the payment of dishonored charges, he can claim all those sums from the principal debtor. Look at this example. B is indebted to C and A is a surety for the debt. C demands payment from A and on his refusal sues him for the amount. A defends the suit having reasonable ground for doing so, but he is compelled to pay the amount of debt with cost. He can recover those amount from the B as he is a surety. He has paid all the cost, all the principal debt, all the interest. So, he can claim from the principal debtor. This is the right against principal debtor. Second right is right against the creditors. So, since there is a contract between surety and creditor, so there are rights, remedies available in the hands of surety against the creditor. What are the different rights? There are 5 rights. Number 1, right to request the creditor to proceed against the debtor. Yes, as he can step into the shoes of creditor, he has a right of subrogation, so he can request creditor to file a case against the debtor. Second, he has a right to set off, to bargain, to reduce the liability. He has, I am unable to make the full payment, but we can negotiate and I can pay this much. So, set off liability. Third, right to benefit of creditor security. Yes, in case he has made the payment, then he can take the benefit from the creditor security also. Fourth, right to require the employer to terminate the employee's services. Yes, since he has stepped into his shoes, he can have that right also, that to terminate the employee's services if there is a justification to that. And last, right to share reduction. He can have that right also to reduce the share on behalf of the creditor. So, these are the right against the creditors. Third right is right against co-sureties. Now, let me explain the meaning of co-surety first. See, co-sureties are those people who have held the responsibility to make the payment in a joint manner, in a severe manner, in a composite manner, in a collaborative manner. So, co-sureties are those who are part of the surety contract. Now, for example, I need a loan of rupees 200 crores. Now, I approached to one bank and bank said, I cannot give you this much loan. We together means my bank, another bank is actually ready to sanction your loan. So, in those banks, one bank is State Bank of India, another is Punjab National Bank, third is Bank of India, fourth is say Union Bank, fifth is Bank of Baroda. All 5 banks collaboratively have sanctioned my loan. Same way, those kind of loans are known as joint loans, collaborative loans, when loan is not sanctioned by one bank, rather it is more than one bank. Same way, co-sureties are existing as a part of the contract of guarantee. So, in case you have taken out a car of rupees 10 lakh, I can contribute maximum to rupees 2 lakh. So, my friend, his relative, his sister, we all 5 friends have given a promise. Yes, we will make the loss good in case debtor is unable to make the payment of 10 lakh. So, I and other 4 members of the contract of guarantee are known as co-sureties. So, co-sureties liability is joint, collaborative and severely responsible. Now, I would say the right against co-sureties. Under section 146, co-surety is liable to contribute equally. Equality of burden is the basis of co-surety contract. This is clearly written in section 146, where when 2 or more persons are co-sureties for the same debt or duty, either jointly or severally, whether under the same or different contract, or whether with or without the knowledge of each other, the co-sureties in the absence of any contract to the contrary are liable as between themselves to pay each an equal share of the whole debt or that part of it which remains unpaid by the principal debtor. Let us take an example. A, B and C are the sureties to D for the sum of rupees 3 lakh rupees lent to E. E makes default in the payment. Now, A, B and C have to make the payment in an equal quantum, that is rupees 1 lakh each, because A, B and C are known as co-sureties and the responsibility and liability of co-surety is equal. This is mentioned under section 146. Next is liability of co-sureties bound in different sums. They may be different in case of the situation called section 147. The principle of equal contribution is, however, subject to the maximum limit fixed by the surety to his liability. Co-surety who are bound in different sums are liable to pay equally as far as their limits of their respective obligation permit. So, if any co-surety has set a bar that I can contribute maximum to this amount, then in that case they are bounded by the different sums. Let us understand with an example. A, B and C are sureties for D. They enter into 3 several bonds, each in a different penalty, namely A in the penalty of rupees 1 lakh, B is of 2 lakh rupees, C is of 4 lakh rupees, conditioned for D's duly accounting to E. Now D defaults to the extent of 3 lakh. If it is 3 lakh and it is coming within the range, say A was responsible for 1 lakh, B for 2 lakh and C for 4 lakh. In that case, they will contribute equally, that is 1 lakh each. For example, D is defaulting the payment of rupees 5 lakh. Then in that case, A responsibility is only up to 1 lakh. B responsibility is only up to 2 lakh. Yes, C can contribute the other 2 lakh because his bar is up to 4 lakh. So, different sums may happen if they have set the bar. So, if there is no bar set by the co-sureties, then in that case their liability is equal. But if co-surety has set the limit into different zones, different bars and different fixed limits, then some may be different from each other. Discharge of surety. Yes, this is the last topic of this session. when surety's responsibility is treated as over, when surety will be seemed or assumed that his role, his responsibility, his liability is discharged. There are different ways. One way is by revocation. So in case surety wants to come out from the contract, then he can do so by revocation, that is by passing the notice as per the contract. So in case contract demands, they must issue 1 month prior notice to leave from the contract, to withdraw from the responsibility. Then by giving that notice, surety can be relieved. Second, in case of death of surety. So in case surety is not in existence, his liability will not be passed to the legal heirs, to the family members of surety. Then it will be assumed the responsibility is discharged. Third, by novation. Novation is actually a contract of newness. When old contract is cancelled and new contract is formed with new terms, new conditions, in that case the role of surety is assumed to be discharged. So if new contract has taken place instead of old contract, then the old contract gets completed over, so the role of surety. Second is by act or conduct of creditor. That means through the usage, action, conduct, the role of surety will be treated as over and discharged. Number one, under this second point, when it will be assumed the role of surety is over. Number one, variation in the terms of contract. If at any point of time contract is updated, revised or changed, then in that case surety will be given an option to be part of the contract or not to be part of the contract. If surety opts second option, not to be part of the contract, then it will be assumed the role of surety is over. Second is release or discharge of principal debtor. So whenever principal debtor is discharged or released, then automatically the role of surety is over. So release or discharge means the debtor's role is over. So when the role of debtor is over, then the role of surety is automatically over. So you could take the help of one example. For example, A has taken a car from a car company where B has given a guarantor. Now let's say A has made all the installments, payments to the car company. So role of A is over, stipulatingly the role of surety B is over. Right? Clear? So when principal debtor is discharged, automatically the role of surety is treated as completed. Third, compounding with or giving time to the principal debtor. So in case the time, extra time has been given to the principal debtors by the creditor, then in that case surety timing contract is treated as over. For example, a debtor has to make the payment within 3 years. So surety is there for those 3 years. Creditor has extended 6 months. Okay, fine, you pay within next 6 months. By giving the extension of the timing to the principal debtor does not mean the role of surety is extended. The contract was for 3 years, so surety can immediately say my time period of the contract is over, so my responsibility, so the liability. So by giving extension to the debtor does not mean surety is involved for another 6 months. Next, creditor's act or omission impairing surety's eventual remedy. So if there is any kind of omission, if facts have been omitted, concealment has been done, material information is not passed to the surety, then surety can immediately say that I am not part of this contract because these omissions have been very important material and they have been concealing the same. Next, loss of security. In case the contract is there by the surety on the basis of some security and that security is lost, in that case the role of surety gets over, right? So when there is any security being pledged under case of guarantee and that security is lost, the very purpose of the contract is defeated, that object is not existing. In that case, when security is lost, the role of surety is over. Third is by invalidation of contract of guarantee. So invalidation is done with the help of these four methods. So in case there is any contract of guarantee which is invalid, unenforceable, illegal, then the role of surety is assumed as over, as completed. Number one, if it is obtained by misrepresentation. So in case any kind of contract which is existing between debtors and creditors, creditors and surety, debtors and surety is obtained by misrepresentation, by folding the facts, just touching with the raw figures or not telling it in a righteous manner. In that case, if consent of the surety is obtained by the method called misrepresentation, then later on if surety comes to know about the real picture, he can claim the withdrawal from the contract, and withdrawal will be very much legal, legible and legitimate. So if at any point of time the guarantee contract is induced, obtained by misrepresentation, then surety can have that claiming. So misrepresentation is when the facts are represented in a wrong manner, not in a righteous manner. Second is if consent is obtained by concealment. That is very important, where material information was supposed to be disclosed by the debtor and debtor conceals that information. Debtor hides that information. So surety is not given a true picture. He has shown the green picture, whereas the picture is grayish. In that case, material information, relevant information is not righteously transparent. So when those facts are hidden from the surety and surety comes to know after creating the contract, he can immediately come as a withdrawal and it will be concluded that the contract of surety is very much discharged. Third, co-sureties does not join. Yes, in case there is a contract between sureties and co-surety is not ready to join in the contract, then the role of surety is treated as over, because A, B and C have mutually given the responsibility to bear the loss of rupees 1 lakh each, and in case they are not joining for that responsibility, they have withdrawn from the contract. So by withdrawing from the contract of co-sureties, the main surety is eligible to get withdrawal also. By that way, it will be treated that the responsibility, the liability of the surety is over. Fourth is when they lack essential elements of a valid contract. That means if at any point of time the contract of guarantee is not suitable and matching with the section of 1 to 75 of Indian Contract Act 1872. In that case, it will be assumed the contract of guarantee is not a legal contract anymore. So, we must conclude that if at any point of time these special contracts are lacking in terms of any essential element, for example, the object is not legal now, parties are not capable enough, or parties are disqualified by the law, or there is missing consideration. All these features, whenever they are missing in these contracts, then the contract will automatically be revocable. So, with this, I just wanted to conclude, my dear users, that whenever any surety is responsible for making the payment, the liability of surety is joint, coextensive, and in case there are co-sureties, then they are liable equally and severely. Keep learning, keep using these notes. Thank you so much.